So the question that I have is, could you please share one such highlight from your great career that you have had, which you will forever cherish? I mean, there would be many of them, but one particular instance or highlight that you would like to share and you'll cherish forever.
I think there are several. The one that I think, the minute you asked that question, which sprang to mind, I think is the recognition that you get externally by people you hold in very high regard. So I remember in 2004, I was assisting Mr. Venugopal, who was my boss then and who's now the Attorney General, in a case. And I had made these detailed notes, etc., in that matter. And it was a case involving a newspaper out of Pune and their shareholdings. And one of the other lawyers also appearing on the same side was Mr. Nariman, Fali Nariman, the senior Mr. Nariman. And we had always been in great awe of him and his tenure as a litigator and as a doyen of the legal profession. He started practicing law in the year that our constitution came into force, right? 1950. Yeah. So Mr. Nariman has been practicing from there. So when you look at the man, you're like, he's held hands with the constitution from day one. So, and I was always passionate about constitution. So when I worked on that matter and he noticed the kind of assistance I was giving, almost a year later, he was arguing, or 2 years later, he was arguing this very important case which went to 9 judges called IR Coelho versus Union of India, which concerned the amending powers of the constitution and the cutoff dates for how you can apply the basic structure doctrine. So he got in touch with me completely out of the blue. And he said, I want you to assist me. I want you to be second counsel on this matter. I've told the solicitors. And that was a very tight hearing, 5 days, and that hearing was completed. Chief Justice Sabharwal, sitting at the head of 9 judges, just ensured that we had a very strict timeline to hear that matter. It gave me prominence, it gave me recognition. It also forced me to read and understand and exchange ideas with Mr. Nariman, because at the heart of that was the reading of Shankari Prasad, Sajjan Singh, Golaknath and Keshav Nanda Bharati in full to understand exactly the scope of 368 and the constituent power. So the amount of learning and reading I did there was virtually unparalleled. And the kind of, I think, my vigor for constitutional law really got a fillip by that recognition that he gave me and the opportunity he gave me. So for me, that is something I really, really cherish, because I wasn't in his chamber. There was no reason for him to reach out. He just did that. He took a fly on somebody, and I'm very grateful to him for having done that.
Good afternoon, sir. It's a pleasure hearing you today.
Hi.
So my question was with regards to your work in the for the Constitution in Bhutan. So as a litigating lawyer, I've seen a lot of opportunities in the field of public policy come in. As members of different commissions, or as different such opportunities. So how can you tell me the process of how does it come to as to what role does a litigating lawyer, play in such public policy decisions? Number one, could you just, in a brief, tell me how you received the opportunity for, with regards to the constitution in Bhutan, and what was your role there, and something on those lines, if you could speak on that.
Yeah. No, thanks for the question, Debarka. My own role was, as I've said before, a very modest one. I was working in the chambers of Mr. Venugopal, a constitutional stalwart and very, very well known internationally for his constitutional law expertise. He had been the head of SARC Law, which is an organization of the legal representatives of the various SARC countries, etc. And because of his prominence, the countries like Nepal, Bhutan, and Sri Lanka had reached out to him at various points, asking for assistance on either drafting their constitutions, the later editions, or coming up with a constitution for the first time, as is the case in Bhutan. This was sometime at the end of or middle of 2003 towards 2004, that the erstwhile king, Jigme Singye Wangchuk, reached out to Mr. Venugopal and said, look, I want to convert my monarchy into a democracy, a republic, and have the republic obviously governed by a constitution. So could you just take us through the constitutional process? So he sent his law minister, the chief justice of Bhutan and all that. And most lawyers in Bhutan and judges have all learned their law in India, in many colleges in India, and they've gone back and reached high positions there. So I was assisting Mr. Venugopal in that regard. So it was my job to do the comparative constitutional law research, to go through the various provisions internationally, see what best fits. It was almost like they did have a Constituent Assembly also, but this is more the drafting committee's job, right? Like what Ambedkar and Co did. So I was one of the and Co types. So I just helped put the stuff together, make charts, give ideas, etc., etc. One amusing thing is that when they first came with a completely sketchy draft, they had copy pasted from the Universal Declaration of Human Rights and from the American Constitution, the Indian Constitution, etc., and put together. And there was a provision for abolition of slavery. So I remember us asking them, do you have slavery in Bhutan? They said no. Then we said, why do you have a provision to abolish something you don't have? So it was a lot of engagement to understand from them, because we didn't know too much about the society and culture of Bhutan. And therefore, we were coming in as foreigners advising on a country's constitution. So we had to understand a little more about their culture, their polity, their society, to understand what clauses work, what doesn't work, what is important for them. They believe in gross domestic happiness as a goal, which is the only country in the world which does that. So all those things came together, and that's how my role came in, really, as an assistant. So it's not really my story as such, but it's something that I played a important enough role, a small but important enough role, which if I were not doing it, one of the other associates in Mr. Venugopal's chambers would have done it. So that's to answer the first part of your question. To answer the second part, a lot of public policy work which practicing advocates do, they're not usually the first choice for public policy work. They always look towards academic circles and public policy outfits. So if tomorrow Parliament had some legislation that they had to deal with and they need comments from, or if there's a working group within a ministry that needed assistance, or if there was a minister or an MP or an MLA who wanted assistance, they would first go to a university, a law university, and try and get assistance from there, or the Indian Law Institute, which does a lot of research work in that area and segment. They would then reach to public policy outfits like the Center for Policy Research, SamVidhi does legal policy work, etc. And it's only after those options that they will come to practicing advocates, because very honestly, I don't think they look around and see too many practicing advocates who have an academic side to them. They take a brief, bahas karte hain, ghar jate hain, full stop. They don't think of them as people who are thinking deeply and writing a lot about it. So especially published work, if you look at the top lawyers in this country, I won't take names, but the names that you read in the newspapers every day, you would find it hard to come across articles written by them, and articles of erudition. They may just have written an article because they have to give a speech somewhere. But where you come in with a completely new angle or a completely new perspective, where you're actually raising questions which people haven't noticed before, that's rare among the legal practicing sort. Now, I'm not saying it doesn't happen, but it happens rarely. And for it to happen more often, unfortunately, one of the big things that plays a role is politics. People who are close to political parties, who play a role either a spokesperson or are attached to some political parties, are given those avenues and opportunities a lot, right? So particular state governments will appoint some people, ask their assistance, etc., to working committees and stuff like that. So that actually plays a much larger role than actual objective excellence in a particular field. And the last thing is, usually, like the Law Commission, for example, whenever it puts out and invites comments on its report, it's put up on its website. So you, me, Mehar, anybody can just write in and give their views. And the Law Commission will, if they think that they're robust enough, annex it at the end of their report, and they will make a reference to you and what you have contributed. So that's something that is absolutely no problem. You can just write in and tell the Law Commission that you have those views. There are many notices that come in newspapers as well, inviting comments on drafts and other things, which people could take as an avenue to do that. And finally, publications. If you have authored a book or you've authored a bunch of articles on a particular field, they're likely to turn to you first. When Ms. Indu Malhotra, prior to her being a judge, if they wanted consultation on amendments to the Arbitration Conciliation Act, Mr. Bachawat would be the first few people that they would turn to because they had written books on this subject. Right? Similarly with criminal law, I mean, if you see the people who have edited the recent volumes of Ratan Lal, Dheeraj Lal, if you want to do something with tax reform, you're likely to ask Mr. Arvind Datar, because they've all authored books. So that's the other way that you become part of a consultation process.
Thank you so much, sir.
You're welcome.
I have a question.
Yeah. Hi, Veera.
Hi, sir. So I think litigation is largely seen as a very, like you said, just get briefed and go and argue in court. But I've always thought that, at least strategic litigation is very multidisciplinary in a sense. It engages with research, it engages with academia, it engages with activism. So you feel like somebody who's purely interested in strategic litigation and that interest coming from strategy and research can thrive in a profession like litigation? I mean, is that something that you can only focus on?
Yeah, but I think you can focus on that. Unfortunately, I think it becomes a little too mercenary at some point. You find too many people just bothered about success being measured by victory, and then you decide to do what it takes to get that victory, and you forget then, or you eschew, or you take shortcuts. And I'm not the happiest with that. I would, personally speaking, I mean, if I were paid reasonably well to become a full-time academic, I would drop this right away. I know it may be surprising, but it's something that I would love to do. I prefer teaching, I prefer writing, I prefer spending time in solitude in a library surrounded by books for hours, where I can actually dwell and think and reflect on what's happening. Because I find that when I do that in the courts, I find very often that a lot of it is wasted. You spend a lot of time and you're hoping that the judges will allow you to develop and engage, and even the other side will develop and engage there. But unfortunately, that's not been happening too much. There is the weight of too much case law and too much pendency and short time limits and stuff like that. But I find that our engagement isn't happening enough. So strategic litigation involves, I think, to a large extent, a substantial foundation of knowledge, which allows you to channel that to making your strategy stronger, make it more robust and more incisive. And I don't think these two are very clearly distinctive, but I find that there is a huge gap today between the academic world and the actual practical world of litigation. And I find very few attempts to bridge that. Shamnad and I tried doing that 10 years ago with a patent dispute, and we were hoping to repeat that with other academics and stuff, but it's not really happening.
Okay. Thank you, sir.
Welcome. Hi, Asta.
Hi, sir. So I have a question that would you like to just share your experience and the atmosphere between a judge and a lawyer in a courtroom?
Wow. Well, I think, and this is a slightly larger issue, I think we as Indians, forget specifically about courtrooms, we as Indians are always looking for people to put on a pedestal. So we are always believing in these idols that we build up, right? So we don't believe in perspectives, thoughts, and policies that people really put out. We talk about them as personalities. So today it's Modi versus Rahul Gandhi. You don't talk about Congress versus BJP. You don't talk about the specific policies. It's just about personality. And we've always been like that. Every rupee note of ours has only one person's photo on it. It's like nobody else ever existed in thousands of years of our history, right? So we've always been obsessed with that. And for me, I think one of the important perspectives, and I keep talking about a lot nowadays, is that in our preamble, we have the concept of fraternity. We don't talk about fraternity enough. We talk about equality, we talk about liberty, we talk about everything else. Fraternity brings in everything else with it. I know it sounds like I'm not answering a question, but I will answer it. The reason is, if you within yourself feel that, look, we are all equal, we are all discharging specific duties. Some of them are discharging duties which you may not find palatable, not something that you like, but that's what they have to do, and you respect them for having to do that, right? Maybe you wouldn't do that, right? I think it makes it so much easier for us to engage with others. For me, in a courtroom, I am a lawyer doing my job, that is being fair with the court and trying to do the best for my client. It's not very hard to do that. Unfortunately, we have overcomplicated it by almost becoming like people standing with begging bowls towards some great idol or god. Judges are not that. Judges are us. They're normal human beings with all the flaws that we have, and they have come to that job and they are doing their job. We have grown up, I think, with generations of lawyers who are always, I beseech your lordships. Your lordships are so kind and generous. I mean, please, yeah, that kind of flattery you can forget about. Let's just tell them that, look, these are the facts of the case. This is what my client wants. I hope you'll be able to give it, right? You can be pleasant, you can be kind, you can be considerate while doing that. Unfortunately, too often, we have gotten them used to being beseeched to, being begged from, that when one guy comes along and who's not begging, they get angry. They think that they can issue all sorts of invectives against them, yell at them, scream at them, and abuse a lawyer. A lawyer and a judge are a part of the same fabric of the court. In light of all this Prashant Bhushan's likely to be punished tomorrow, etc., etc., I think people forget that there are sections in the Contempt of Courts Act and at common law with reference to contempt that judges can be guilty of contempt as well. It's contempt of court. It's not contempt of judges. So contempt of a court can be done by lawyers and by judges and by litigants, by court staff, anybody connected with the court. But they're all equal parts. They're all four wheels on which the court runs. So we must treat them as equals. The mistake we make as lawyers is by not treating judges as equals and getting them used to believing that they are on a higher pedestal, that they are somewhat different. They're not. They're discharging a constitutional obligation for which they are getting paid by the government. That's their job and they have to do it. And I must tell you that nearly about 70 to 80% of the judges do that job in a fantastic manner every day in this country. Especially in the lower courts, we have seen some of the quality of the judges that are coming into the profession, very young people. They must be like a few years older than each of you. They've come in and it's been a refreshing change. People who really understand law, who want to really get into it, who are not like spitting pan and chilling out like in that movie, right? They're that jolly LL.B kind of judge. We have fewer of those now. We have more people who are really dynamic and who want to make a difference, right from the district courts and civil courts and stuff like that. So I find it I'm happy to see that more of the judges who are feeling entitled are more of an aberration, and I'm happy to see them go. I think it's good to have young blood who realize they're doing a job, we are doing a job, and we're all equals in this.
What is the role of media in criminal trials? I mean, there have been instances in the past where it has helped. So, to what extent it should elongate and when it should come to an end?
Because we believe in strong free speech laws under our constitution and the freedom of the press, we have always been hesitant about in any way trying to limit or trammel the power of the media in covering cases. Inevitably, you will find, not only in India, but anywhere in the world, criminal cases are the ones that grab more eyeballs, which are in the press all the time. This is not unique about India. 2 months ago, the British courts had several cases going on, but the only one that got coverage was about Johnny Depp and the Sun newspaper. And the British lawyers themselves were very upset because there were many, many cases which were much older, which should have been listed and been heard. But this about her, his estrangement and all the allegations made, were holding the front page on every single day, was being discussed on television every single day over a 2-week period. Now, we've seen that in the US play out with the O.J. Simpson trial and many other trials which have had that kind of media orientation about it. Very rarely do you find in non-criminal case really having that kind of attraction to it. Very rarely. Now, it's really left to the media about what they will choose to cover, because that's not something that we or anybody else can decide to control. Many of us as citizens play a role, those who are on social media and who contribute by way of Twitter and Facebook, etc., in allowing those stories to grow. So the digital space has been occupied a large extent by non-traditional media actors. So many of you here might have at some point either tweeted or shared on Facebook some story dealing with Sushant Singh Rajput, right? One perspective or another, because as lawyers, you would have views. There are many others. Everybody is a lawyer today, sitting in their drawing rooms, watching a TV channel and figuring out what the position is. So the more all of you talk about it, the more the traditional media will pick that up and talk about that in a big way. And you're right, media has played an important role back in the day. I remember that Nirbhaya case. The Nirbhaya case was not unique. Gang rapes had happened before in Delhi and its surrounding areas. It had become unsafe for women. But NDTV decided to pick that up and make a big story of it on the night between the 16th and 17th of November that year. And that's why it became a big story, because one channel picked that up. And at that time, it was being watched quite a bit and became a story that ran. Now, there are many other stories which are equally unfortunate, but unfortunately, it doesn't get that coverage. There's no real solution to this. I guess a lot of it has to do with education and with us understanding what our courts do and what our laws are and what our constitution contains. Because very often you find that citizens don't understand that. So for them, this is more like a tamasha. And everybody wants a piece of it, especially because you're talking about somebody who's from Bollywood, who's been at the heart of this. That's a big deal.
Yeah, sure.
Gopal sir, so my question is that a lot of, the recent developments have been that the government is trying to propose for all India judicial services one common exam under which the judiciary should be conducted instead of having a state-wise manner that is currently existing. So can we have your thoughts on the same? Do you think that will be more efficient and provide more opportunities to people, or it will be contrary to what it should be doing?
I can't comment. I don't know enough about the selection processes and how they have worked, whether good candidates are coming through or not. I don't know. It's like the never-ending question which we've been having in the courts for years, whether the collegium process for selecting judges in the high courts and the Supreme Court, is that better than an alternate process which may have come through the NJSC? The view is that, look, lots of decent people have come through the collegium process, but many who are not palatable have come in. More importantly, lots of really deserving people have been excluded. And we've been seeing that happen by the dozen. They get transferred. 2 resignations of Chief Justice of High Courts have happened in the last 1 year. Unheard of, unprecedented. We've seen judges getting transferred, not getting considered for Supreme Court judgeship, names being put up by the collegium and proposed, and then being rejected on some random IB report. So I'm not sure if we have a foolproof, and we ever will have a foolproof method of selecting judges. So the same problem that attends the collegium NJSC divide and debate is something that is also going to attend the question of whether you should have an All India exam or you shouldn't have an All India exam. Because in all those processes which exist at the moment, there is an examination, there is an interview conducted, which have judges of the High Court present who decide on members of the subordinate judiciary. I have no reason to suspect that system is worse off than a centralized system. It's like today asking, you have the IAS exam being conducted by the UPSC and they have a process. Now, if you decide to come up with a different process by which you break it up state-wise and say, why have an all India service? Just have only the state service. I don't know. I'm not sure if I have enough data to comment on. I haven't come across any empirical discussion which is the basis of this policy change. So very honestly, I can't really comment one way or the other on what really works.
Thank you, sir. The next question is from one of my batchmates who is attending the session, but due to network problems, he is not able to ask the question. So I'll ask on behalf of him. It's for a person just coming out of law school who wants to litigate. How should a person go about looking for an office to work in? What factors are important to be considered?
Well, I think step number one is not to waste your internships. The internships, and I've said this in another discussion at some point, that it's not the certificates ticking off stuff. It's the internship itself. It's a kind of work you put in, the way you impress the people who are in that office. And that could be one of the avenues by which later when you're graduating, they may want to recruit you. But the most important thing is for you to look at offices which you will have to do the research for this. This is the hard work because this can determine what your career in litigation can be all about after that. Is to first look for an office which has a reasonable amount of work, which means that they are likely to be in court every single day. If you're in litigation, ideally you should be in court every single day. It doesn't matter which court, any court, but there every single day. The second is that you can find out, and you will know generally from seniors and others, whether that office enjoys a decent reputation, whether the individuals who man it, the others in it, have a decent reputation as being people who are not unscrupulous, who are not unethical, who don't try fast tricks, who actually spend some time, doing the decent work that clients expect from them. And the third, and this is the most important, and this is where I think the biggest mistake happens. Do not choose lawyers based on how often their names come in the newspapers or on TV or because they have a Twitter account with 80,000 followers. That's the worst decision you can make, and many people have made that decision and they have had to rue their fate for it, because it's very different to argue on Twitter with a assemblage of people who don't know better, mainly members of the public who are not experts in law, who are willing to accept whatever you tell them, and turning around and trying to say the same thing to a judge who will throw you out in 3 seconds. So the idea is, don't get swayed by the fact that somebody is very prominent and is very sound in a TV debate. Being sound is a pun when it comes to a TV debate nowadays, because the louder you are, it seems that you have more impact. Now, it's like if Arnab Goswami were a lawyer, you're going and saying, "Mujhe uske saath kaam karna hai." That you don't even know how effective he is in court. You haven't worked with him. You don't have an idea. Go work. Just see, intern. See, are those arguments making sense? Is there a lot of hard work going in it? But at the end of the day, that person, that man or woman, or that group of people you're working with have to be decent human beings. And that's really, really not easy for you to find out by standing on the outside. That only through internships or having somebody close to you who's worked there who can tell you the truth. Are they going to be harsh? Are they going to be obnoxious? Are they going to be vindictive? Are they not going to involve you in cases? Are they not going to give you work to do? Are they going to ask you to staple and Xerox and feel that that is very important and that's enough for you? Are they not, and this is also very important, are they going to tell you, the minute you start working with me, you can't do any independent work at all? You will only do my work and you will not do anybody else's work. For me, that's a no-no. There's no question about it. The idea is you guys are professionals coming into this profession. The only way you can build and grow is by slowly, small opportunities come. Somebody will say, "Yahan kuch file karna hai, Dwarka mein jaakar karo. You help me with this drafting. Here's the material, do that." You should be generous enough as a boss to say, "Ha, please. This is the only way you'll grow, yaar. You're not just going to grow just being with me. You're going to grow with all the opportunities that come your way. So I think it's very, very important to understand that these are, for me, red flags. If you have a boss who's not going to let you do that, if you have a boss who says, I'm not going to pay you a penny, it's your fortune. For 50 years, many of us have not been paid, therefore you won't get paid. None of those arguments for me cut it. And also, if your boss is the kind of guy who is charging like 25 lakhs to appear in one case, right? And he appears 40 times a month, and then he pays you like 20,000 rupees. That's for me really, really mean. I say this only because I'm extremely conscious of the fact that there are many, many people who find it very difficult to make ends meet. And they are at some distance from achieving anything close to their dreams only because they're deprived by having made the wrong choice. Remember that when you plight your troth, as it were, with an office, you're committing yourself for a substantial amount of time. It's like applying to a college which you have no idea what it does. You wouldn't do that, would you? You wouldn't go and marry somebody you just met the first day. If you're not going to make those life choices, why would you make one of the most important choices in your life based entirely on that person's reputation on Twitter, or them, even if they're the greatest lawyers in the country, they may not be great bosses. Remember that. You will know that only by looking at their chambers, seeing who their previous juniors were, and seeing, oh, those people have done well. Therefore, you're looking at the alumni basically and saying, oh, if they have done well coming from that chamber, maybe that chamber has something going for it. And for me, that was not a difficult choice when I joined Mr. Venugopal's chambers. He's produced more senior advocates than anybody in this country ever. He's produced, I think, 24. Okay, so for me, the fact that, and he was a great guy. I had interned with him. I knew how generous he was. I knew how he used to engage with even interns and say, what have you done on this? Tell me. Most people don't even look at their interns. The intern is usually working only with that junior of the senior, and you never get to meet the senior. He would actually call the interns in, put stuff on their head, make them work, get feedback, etc. And he continues doing this at this age, 90. I mean, 89. I don't know if I'd be able to do that even now. Right? It's amazing to have a person like that who you can use as a role model and an ideal of how a boss should be. So I think those are broadly the things. Remember the red flags. If the person is not going to let you do your independent work, and if the person is not going to pay, I think those are two very important things. And third, if they're not in court every day and they're more on Twitter, I think that's a third important red flag.
Abhiraj has some questions.
Hello, sir.
Yeah, Abhiraj. Hi.
Before we take up the questions in the chat box, I just have a question which is related to the previous question only. Yeah. So, sir, there is this disparity in terms of remuneration which distracts and discourages a fresher from joining litigation in the first place. How do you see a senior's role in this aspect when it comes to internship and in the job as well?
I think a lot of it is based on the capacity of that person. Okay, I don't think a senior should take on a junior or an intern and expect that person to work without giving them some remuneration. Even an intern deserves some remuneration for the effort and the expense of coming, dragging themselves all the way to your place of work, working with you, assisting, helping, etc., etc. Because true, they're learning, but they're also assisting and helping. So I think it's very ungenerous and inappropriate for a senior not to be doing that with both a junior or an intern. But I think a lot of it has to do with the capacity and the profile of the senior, the kind of work they do. If they are seniors who are doing a lot of extremely lucrative, money-oriented work, I think that has an important role to play with what their bandwidth could be to pay and whether they are or not ascribing to that bandwidth. If you have a person who is more limited or is doing a lot of pro bono and PIL work, etc., etc., there would be those inherent limitations in them being able to pay you the big bucks. But you will get to learn and get an exposure, and there may be a reasonable amount that you may make. And like I said, supplementing your income by doing independent work would be important at that stage, which is why that is also important, where you learn new stuff, but you get your income supplemented. Now, different things work for different people. I'm not sure that there's a single formula that's ever worked for any single person. Even now, Mr. Venugopal and I have a very strong agreement about how you should, if you want to practice, where you should start. His belief, and many of the people of that generation, are that you should start in the district court, spend a few years there, go to the high court, spend a few years there, then if you want to move to the Supreme Court, do that. I believe that they are not a vertical arrangement. I don't believe that you graduate from one to the other. I believe that they are actually running on parallel tracks. So you can just do district court work, start there, end there. You can start Supreme Court, end in Supreme Court. So I don't believe you graduate. Of course, you build skill sets across places, but a lot of it has to do with the visibility quotient that you have, which you build up, where people recognize you, identify you, judges know you, see you on a daily basis, and realize that you're a lawyer with a particular kind of caliber, etc., in a particular court. If you spread yourself thin across different courts and spend 2 years here and lose the visibility quotient because you go now to the high court and then spend a few years there and go somewhere else, I think you lose a lot of what you build up in the very social congregating style that we have at the courts.
So there are some questions in the chat box as well. If you
In the chat box, is it? Let me look at that. The scope of entrepreneurship in this field, that's actually very wide, Ashutosh, because it's difficult for me to say with what particular idea you have of entrepreneurship. We have seen it working successfully for people who set up apps for knowing codes and item numbers and giving people a heads up on that. There are websites, Indian Qanun, most famous among them, where you can get judgments of any of the courts at any point of time, which is free without having to pay for it. You don't have the head notes, but you get the judgments. So that's a quick way of getting it right through a Google search. So that level of entrepreneurship, I think, works. There are lots of people working in the area of AI, artificial intelligence, particularly in transactional legal work. There are others who are working on the Naukri.com equivalent, trying to find offices and trying to find people who are good enough for those offices on the HR side. So I think that's another area where there is scope. So I'm not sure. I think there is a lot still to be done, and lots of solutions, particularly with reference to technology, that we've seen over the last few months, which could be tailor-made for lawyers and how we function in the days to come. So I think, yes, I think there is scope for entrepreneurship, but it's a very wide question. So, I think there is definitely scope, but I don't know in what particular field you're talking about or which direction. Ratan Meek, how important is LL.M for a person who would want to pursue public law and civil liberties? And if one should work for some time before deciding to do LL.M. I strongly believe, I think it's always good to work for a while before doing an LL.M. It gives you a very strong perspective, unless you've already made up your mind about a particular area which you have a very strong academic interest in, which was true for me. But otherwise, I recommend that you work for a while, because not only will it help you open more doors admission-wise, because they always look kindly upon, and even scholarships-wise look kindly upon people who have a certain amount of work experience under their belts. I think in areas like public law and civil liberties is actually extremely wide nowadays. So many of the foreign universities expect a little bit of focus even within the spectrum of civil liberties. So if you've worked, say, on digital freedoms, on the role of intermediaries, closely with the IT Act and the Data Protection Act and stuff like that, that gives you a certain amount of focus which you could show on your CV as being strong enough for you to pursue an LL.M in that field, rather than saying civil liberties at large. There could be specific areas with reference to how riot victims have been dealt with, proceeded against, victims have been treated as the perpetrators of the offense, the questions of bail, the various aspects of those things that we have seen, particularly in the last few years. And focused work in those areas on the ground, helping those people, is always extremely useful when you want to apply in go abroad. So I think that would be extremely useful way to go about it.
Um,
There
can
Yeah.
you
is a
please
question.
tell us your experience in the virtual court? Like in the light of COVID, everything is virtual.
Yeah, yeah,
So,
yeah. Well, I must tell you that the Supreme Court's platform which they're using, it's called Video, VIDYO. It's abysmal. It's the worst system in the world, and they should never have used it. We struggle with it on a daily basis, especially because it's virtual. I've had the opportunity to appear in many of the other high courts. So many of them use Google Meet. They use WebEx. Some of them have been using Zoom, and all of it without difficulty. Zoom and video occupy opposite ends of the spectrum. Um, Video requires very high broadband. Zoom doesn't. It requires very low broadband. And the minute, for example, in large batch cases, if you have more than about 60 or 70 people logging in, it becomes extremely difficult for any more people to log in. And so what the Supreme Court does is they send us a link for all the cases in one particular courtroom. Supreme Court is not hearing that many cases, but maybe about 30 cases a day. So in each courtroom, we get that one link and all of us log in. And then the rest of us are muted when item 1 is called out, then item 2, and we move on. So at any one point of time, you clearly have 70 to 80 to maybe 100 people. If it gets a little more than that, nobody's able to log in. There are audio issues. There are video issues. We get muted, unmuted. We don't have control over our video very often. We are waving and telling the judge, please unmute. It could be better, but this is not the platform for it. Video is clearly unfit as a platform. I would hope that we could use WebEx or Zoom, Google, or any one of the other things, Google Meet, etc., etc. And unfortunately, that's not the situation today. I'm quite happy with the other platforms. I've used them and they've been seamless. There hasn't been a problem with the others.
Yeah. Dia has a question.
Yeah,
Hello,
Dia.
sir.
Yeah.
Since sir, court mannerisms is very essential in a court, and sometimes the remarks by judges can leave you baffled. And as my moot court experiences, I've experienced that. We've all had that. So, what do you have to say when the arguing lawyers are quite taken aback by the judge's remarks, and the expressions are quite evident on their faces?
You're talking about in the context of video conferencing?
No, sir. In the actual court.
Well, we always, it's very difficult to figure out. I mean, one of the reasons why I prefer the physical courts actually to argue with is that I can see the reaction of the judge when arguments are going on. I'm not really looking at the lawyer on the other side because I perceive that sometimes, I've seen many lawyers do this. Mr. Jethmalani, the late Mr. Jethmalani used to do it very often. He used to make a particularly strong point, and then he used to put one hand on his hip and turn around very deliberately to look at the lawyer across to say, look what I did, kind of thing. So each lawyer has his or her own mannerisms, and it's very different, and it's sometimes amusing, it's sometimes irritating, but it's what they are. It's what we all are. Many of us are performers, I think, in court, and there's a little bit of the dramatic. Some are extremely dramatic. So it's all very well. I mean, I don't think we should bother reacting too much to the way lawyers behave and how they conduct themselves. We should try and just, keep it mellow instead of getting aggressive. But it's very important to see how judges are reacting, because when you're sitting quietly and the other side is arguing, you're noticing if they pick up the pen and start jotting something down, that means that man has made a point. So I have to jot down the same thing to make sure that I can reply to it later, because the judge has taken note of it. If you feel that the judge is not listening, he's like almost dozing off, then you really don't have to bother what his submissions are, because the judge doesn't seem to be bothered by it either, right? So I think a lot of it has to do with that. On our video screen, we're not able to figure that out. Body languages and stuff like that. It's not very helpful. Yeah. So I mean, that's broadly my view. There's a question on the chat from Soumya Sinha. What, according to you, are the things which a first-generation law student aiming at litigation must have in mind while in law school? What advice would you give to such students? I don't think that advice would be different whether you're a first generation law student or a fifth generation law student. I think it's just about ensuring that you don't overthink your future. I think too many people do that, and you lose out on the enjoyment of life when you're in college. You must try, and when you're in college in those years before achieving adulthood and going out in the big bad world, try and enjoy your life a bit. Do other stuff, make friends, go and play, travel if you can, do other stuff as much as you can, because I think that's very important. Read, write, do, sing, dance, do whatever you want, so that you can get some balance in your life, because it's going to be a long while before you're going to have life that easy and pleasant anymore. So it's very important for you to do that, I feel. And I feel as a first generation lawyer, the only thing you know is that you don't have somebody who's going to really give you a walk-in into their office. So concentrate from your first year onto trying to land some decent internships. Every internship doesn't have to be Harish Salve, Fali Nariman, Venugopal. It can be internships with young people who are doing decent work, who'll have work to give you, who'll have time of theirs to give you, right? All the big guns don't really have that kind of time and that kind of space to really accommodate you at that time, especially if you're a first year or second year. I personally don't. I tell interns who apply to me that I want people who have done third year and more. Because I mean, you may be very good, you may be outstanding, you may be a baby genius, but I would prefer to give those opportunities to people who've spent some years doing that. So I think it's important for that background to be there, where you've done some internships, etc., etc. So you've tried to make an impression on people, and so that's your best option to farm it out. As a first generation lawyer, that's the most important thing for you. You have to get some security that you're going to land something when you graduate.
So I have a question with regards to one of your, in the case in which you appeared. So Dia mentioned about that case in the introduction as well, the right to privacy case. As far as I remember, you had some different views in that particular case. So if you could enlighten us with some of those, I mean.
Oh, I'll keep it as brief as possible. It's actually going to take a while. One sec. I was appearing on behalf of an intervener, the Center for Civil Society, in the Aadhaar case, before the Aadhaar law came in, right at the outset in 2014 when it was first challenged, or 2012 or 13 when it was first challenged. And the idea was basically to say that Aadhaar, as long as it's not made mandatory, is fine, and therefore we support the government on the Aadhaar project. Now, what happened is that enrollments were going on, and indirectly we had helped in ensuring that it got referred to a larger bench on the question of whether the Supreme Court has laid down that privacy is a fundamental right. Because it was a presumption that the petitioners were taking that privacy is a fundamental right, so therefore this violates a fundamental right. We said, don't presume that it's a fundamental right. We don't think that the case law supports that view. On that basis, it was sent to 9 judges, 5 judges first, and Chief Justice Kehar sent it from 5 to 9 overnight. When it went to 9 judges, the issue was no longer about Aadhaar and its validity. It was about whether there is a right to privacy or not. Now, it's a much, much bigger question. And as lawyers, we have a responsibility, not only to your client, like I said at the outset, but towards the court and towards the development of our constitutional rights. Both me and the Client Center for Civil Society were in no doubt. Obviously, if you want to support the Aadhaar program, it's easier to say that there is no right to privacy at all and try and argue that. But our conscience would not permit us to argue that. So what I argued is that there is a right to privacy. Everybody on the government side argued that there is no right to privacy. I argued there is a right to privacy, but please ensure that you have it defined, because hurdles will come, which will be difficult for you to wriggle out once you declare such a right as a right. Because many parts of the right to privacy had already been declared, and we didn't want that to be diluted. Many tests which existed for fundamental rights would possibly have to be moderated, modulated, regulated, and changed when you're talking about the right to privacy. One example which I gave them was about the right of waiver. Technically, as per old case law, you can't really waive a fundamental right. I argued that if you make privacy a fundamental right, that means I can never waive that fundamental right, which means that I can't even give or concede a little bit of my privacy for whatever reason, which may be important for me, which I may want to do. I'm a patient on a hospital bed and I have to give consent for an incision to be made in my arm. I have to sign off on documents. Now you tell me it's a fundamental right of yours, therefore you can't waive it. So I said, constitutionally, normatively, you're going to have hurdles, so you'll have to deal with those. So that was the argument I took. The problem is that when you're on one side of the court for the other issue, people presume that you're on that side of the court for the privacy issue as well. No, I don't have to be. I had to therefore switch on that issue and say there is a right to privacy, but it may not be breached in the other case whenever it comes up for hearing.
There are one or two questions in the chat box.
So if you could tell us about your time over there and how relevant is a master's degree. Master's degree is not relevant in the field of litigation, I think. It's not relevant at all. What is more relevant is your experience in the courts, the amount of hours you put in there, how much you observe and note and take a look at and figure out. So I don't think that's really relevant. For me, it wasn't a plan that I'm going to do something which is going to help me in litigation. I can't think of the last time that I looked back at what I learned in the LL.M and applied it in courts. But I was always fascinated by the theory of crime. Andrew Ashworth and his work has always been an inspiration to me. Nicola Lacey and her work on feminist jurisprudence with reference to criminal law has been an inspiration to me. So I had in my third or fourth year had wanted to always go and study criminology. It was a bonus that I went to a university which had offered different combinations, so I could do criminology with policing and with international law of force. So I was fortunate to have a professor like Professor Greenwood, who later went to the ICJ, as is presently a judge of the ICJ. Outstanding minds, a completely different experience. I always recommend that if anybody could have that opportunity of going and understanding how exactly an academic pursuit could be carried out on a foreign university campus, you should do it. But don't do it with the aim that it's going to give you something thereafter. I mean, that may be your aim if you want to go and work somewhere else, but don't do it with that aim. If you want to just understand how different academic instruction can be, because there's an ocean of a difference even now. And there is no shame in asking questions, in getting responses, in being exposed to some of the finest minds among your contemporaries, among your teachers, and understanding the discipline of research. I think all that was huge. So the one skill set that I've taken away, I feel, is that I have an untiring view about researching litigation law points. I believe that you can never reach the end of a law point. You may do enough for a final hearing, but it's still not the end. You can still go on. So I keep correcting my juniors, interns, etc., who come and say, "Sir, there is no case on this point." I say, "Don't say there is no case on this point. There's no case you have found on this point. But if we search far enough and long enough and hard enough, I'm sure there could be something there." So for me, it was a great experience. I loved it, but it wasn't done with the aim of using it in litigation. It just happened that some skill sets worked for me. So that was the question from Yash. Debarga is full of questions. He says, what are the essentials you would look for in the resume and SUP when a person applies? What are brownie points and big no-nos? Well, big no-nos is saying, dear sir or ma'am, I would like to work in your firm. That means you've done absolutely no research whether I'm a sir or a ma'am. It's a copy-paste from 50 letters you're sending 50 other people. You don't even know if I have a firm or I work alone. So, I mean, those are big no-nos immediately. I would look in the resume and the SOPs for any work that they have done which would be useful or which I'm curious about, which would interest me in the work I do. But I'll be honest about this. I do get internship applications, but especially over the last 6 months, I haven't been looking at it because I'm not very digitally astute to be able to delegate work over the net and over the computer, etc. I have difficulty doing it with my own associates. So for me, I find that, look, you send me a brief online and I do everything online, I can possibly do it myself right away. But having to delegate and then subdelegate and then to get stuff back and then to put it together is really tough. If I'm sitting in a physical office, I can do that. There are papers, I read it and I can figure out who did what and talk to them and interact. But doing this digital stuff is tough for me. So I haven't been accepting any internship applications over the last 5-6 months. But what I would look for is the kind of focus areas which overlap with mine. So I do a lot of constitutional, environmental kind of work. So I would look for stuff that overlaps with that. And if it piques my interest, that works for me. It may not work for other people. They may be looking for other stuff. They may look for grades. They may look for articles. They may look for a good bunch of internships behind you, which also shows your interest so far. So I think it varies from person to person. Sachi, same love for the hustling roads of Bangalore. That's good to know, Sachi. My question along learns, would you recommend a specialized LLM or a general LLM? What is more beneficial, pursuing LLM from foreign university or an Indian university? Well, I can't discount the LLMs from Indian universities. It's just that I don't know enough about them. I've always noticed that, especially on Indian campuses, we have a kind of stepbrotherly treatment when it comes to LLMs. It's always the LLB crew who are the main guys. So the LLMs are like also rans. So we'll also try and send you a teacher if you can, that kind of stuff. I don't really know enough to say that it's great or it's not. But I would recommend, if it's possible at all, to do an LLM from a good foreign university. And also look for what their specializations are. You hear the same names again and again and again. Oxford, Cambridge, Harvard, LSE, NYU, Michigan, Stanford. Those names are bandied again and again because they have reached a level of excellence in all fields of law, almost all fields of law. But if you look hard enough, you will find that there are specific universities which have outstanding work in a particular area, right? So if you talk about international relations, SOAS is outstanding in London, the School of African and Oriental Studies. If you look at information technology and digital regulation, Leeds University is outstanding, some of the best minds in the world. And I find that most people discount those because they're looking for labels. I don't think you should look for a label, especially if you're going into litigation. None of your labels matter. You come from National Law School, you come from some unheard of law college in the deep recesses of the country, it makes no difference. When you start day one, you're wearing the same white shirt and a black coat and a gown that anybody else is wearing. It makes absolutely no difference in my view. So if you're coming back for litigation, just ensure that you have a good campus environment and a good experience at a university which does a comprehensive amount of decent work in that area. One of the things people normally discount when you're looking at foreign universities is the amount of output that they have, research work that they have. We're not accustomed to our teachers and our professors here having either the time or the bandwidth or the inclination to do a lot of published research work. So we don't know that is actually the most important criteria on the basis of which universities abroad are ranked. So National Law School, for example, which I hail from, for many years people have been ranking it at number one. But if you were to use the foreign parameters for National Law School, I don't think it will be number one. I don't think it will be in the top 5. Why? Because you have to look at the amount of published research work by the faculty. Most university faculties in India are so limited and strapped in numbers. They just don't have You won't have a full professor for intellectual property and for labor law and for insurance and for banking and for civil procedure. You won't have full professors for all that, even though the UGC requires that, right? So because you don't, one guy is sitting and doing 3 different courses in 3 different subjects, of which 2 are not his specialties. But in a foreign university, you have 14 guys for one single subject. So 6 of them are taking the subject, the other 6 have that term off to do their research work, to actually come out with compelling empirical work and compelling comparative work and to have that published. So I think that's something that one must keep in mind when you're doing it. And if you have the option of doing a wider LLM as against a specialized one, that's always great. But a wider LLM requires that across those faculty verticals, you have good faculty. May not be the easiest to find that. So you might find yourself a little disappointed in the others. So I'm done with the chat box now.
Okay, so last question from my end on research only. So you have also been contributing to various newspapers. The Hindu is one such newspaper. So what are your advice? What is the advice that you would like to give to the students who have interest in writing a lot? I mean, the blogs or articles, and how to go about writing on pertinent contemporary issues that they have in hand.
Well, if you like to write, I think it's important to keep 3 or 4 things in mind. One, be sure that you have an opinion. Most people don't want to read about something that is ambivalent. They know that. They're getting that from the newspapers anyway. You must have an opinion, and it's good to have that opinion and to put out what your opinion is once you give the background. The second is, remember length. Very people forget length. Most of the newspapers look for a length between 650 to about 800 or 900 words. Longer series, maybe 1,000 words. So you have to make sure that what you're writing is not an academic piece, but a piece for the layman, which requires you to then use really simple language and to make it simple enough for the layman to understand. People who are not well versed in the law to understand and say, oh, wow, that's interesting. The third is, if you want to write academic pieces, you need to ensure that you have enough research done, because virtually in all areas, there's enough research work that has come before you. So you may be going ahead and doing something that's already been done. Your view may not be new. Then don't do it. Because nowadays I find online, there are so many of these so-called online journals, stuff that is being curated by people online, and very proud to say I published this on this online journal, that online journal, etc. There's no point settling for just saying I got published, right? You want to publish and make your voice heard, that's fine. Do it wherever you want. But if it's the idea of getting some recognition out of it, then you have to try and find a peer-reviewed journal or a journal of some eminence which has a unique coding as far as it is concerned. And that requires a certain amount of independent research. It requires an incisive take on that point of law. And you have to be absolutely sure that the position that you're portraying is feasible and practical in law. It can't be something that has already been overruled by some court of law, but you didn't notice it or you didn't find it. So it requires a lot of spade work. Most of the stuff that I have written, at least the academic pieces that I've written, I've had to work on it for nearly 3 months before I've actually put it down in a journal. I take it as seriously as a submission that I make in court. So it requires that much effort. And I'm afraid, I remember a guy in my class in law school when I was in my 3rd year. The introductory class of CPC was being taught. And he wrote down the notes in his notebook and sent it off to some journal which published it. That was his first chapter, the first class of CPC. He said, Introduction to CPC was the title. He put his name under it and had it published and told everybody, I've got so many publications under my belt. I mean, it's meaningless for me. That doesn't have any content really. It's just something just to tick a box and say, hey, I wrote this. Most of the people, especially if you're applying abroad and stuff like that, or for an academic position anywhere, they are not just going to believe that you have written 500 articles. They're going to ask for you for a sample of your work. And they see a sample of your work and they feel that it's not of that standard or that quality. There's no point having done all that work.
Well, I think we are already up.
Yeah. We have
Yeah, it's
overrun by a
running up.
bit.
Yeah.
Yeah.
I thank all the participants, and we are really grateful to hear you, sir, and share your insights on various issues. Um, we'll definitely want to have you again with us over the course of time, and looking forward for the same. I'll also take this opportunity to thank my team members at SamVidhi who have just worked very hard in organizing this inside 2 days of time. So thank you guys. Thank you so much. And again, thank you so much, sir, for having
Thank you. Thank
yeah,
you so much.
invitation.
Yeah, thank you so much for having me. I think it's fun to interact and help you guys with whatever doubts and issues you might have had. And I wish you all the very best. Hope we bump into each other at some point, hopefully in court.
Yeah. Thank you, sir. Thank you so much.
Thank you. Thank you. Thank you very much. Bye bye.